Welcome to Employment Law This Week. I'm George Whipple. An increasing number of businesses are reopening, and many employers are considering whether to have employees sign COVID-19 liability waivers before coming back to work. Is it a good idea? Jimmy O gives us his thoughts.
A COVID liability waiver would say something along the lines of, I release any and all claims against the company if I end up contracting COVID at work. Whether or not that's enforceable hasn't been tested in court, but this is one of those bets that I'd make where the employer would very likely lose because, number one, you cannot prospectively waive your rights against an employer. And then number two, in terms of the enforceability of such a waiver, most states or all states have workers' compensation systems where if an employee gets injured or sick at work and it's causally related to the employment, then you're going to be covered by workers' comp, and workers' comp claims simply aren't waivable. So in terms of having an enforceable waiver of COVID liability, that's a likely loser of a claim. A better solution likely is going to be having employees sign some sort of acknowledgement that you, the company, are doing the best you can to create a safe environment for work in this day and age of a pandemic, and acknowledge that there are safety procedures and a safety plan that the company has put in place, and that asks the employee to acknowledge that they will comply with the plan and the safety plan and all of the guidelines and requirements that the return to work plan encompasses. And so I could foresee a situation where having an employee sign an acknowledgement that they will follow the plan, and then it turns out that they don't want to wear a mask and they don't wear a mask where the plan requires it, then you have potential grounds for disciplinary action. And if disciplinary action then leads to some type of a claim from the employee, that's potentially when you might be able to get a waiver that covers COVID along with a waiver of other claims. So for example, let's say the employee continues to be a disciplinary problem for failing to comply with the COVID safety plan. That employee ends up getting terminated, ends up suing, you end up settling the lawsuit. At that point in time, do I think you could include COVID and a COVID-related illness in a waiver that might be enforceable in court? Yes, I do.
Thanks, Jimmy, and thank you very much for watching. Stay safe, and we'll see you next time.